Small world, the world of informative flashcards. Flashcards and Batas Pambansa Bilang 22 or Anti-Bouncing Check Law. Title of Batas Pambansa Bilang 22? An act penalizing the making or drawing and issuance of a check without sufficient funds or credit and for other purposes. What do you mean by bounce check? A bounce check is slang for a check that cannot be processed because the account holder has non-sufficient funds or NSF available for use. Can a person go to jail for issuing bounce checks? Yes, if he does not clear things up quickly, he may be held liable civilly and criminally. What law criminalizes bouncing check? There are two laws. 1. Batas Pambansa Bilang 22, otherwise known as Anti-Bouncing Check Law. 2. Estafa under Article 315 of the Revised Penal Code. What if the person issued the bounce check in good faith? Will he still be liable? Yes, he's still liable, because good faith is not a defense in Batas Pambansa Bilang 22. What are the essential elements of anti-bouncing check law? The following. 1. The making, drawing, and issuance of any check to apply for account or for value. 2. The knowledge of the maker, drawer, or issuer that at the time of issue he does not have sufficient funds in or credit with the drawee bank for the payment of the check in full. If you are the accused in Batas Pambansa Bilang 22 case, what defenses are available to you? First, the most common defense for violation of BP 22 is the lack of notice of dishonor. Second, that the check was issued merely for accommodation. An act penalizing the making or drawing and issuance of a check without sufficient funds or credit and for other purposes. Section 1. Checks without sufficient funds. Any person who makes or draws and issues any check to apply on account or for value, knowing at the time of issue that he does not have sufficient funds in or credit with the drawee bank for the payment of such check in full upon its presentment, which check is subsequently dishonored by the drawee bank for insufficiency of funds or credit or would have been dishonored for the same reason had not the drawer, without any valid reason, ordered the bank to stop payment, shall be punished by imprisonment of not less than 30 days, but not more than 1 year, or by a fine of not less than, but not more than double the amount of the check, which fine shall in no case exceed 200,000 pesos, or both such fine and imprisonment at the discretion of the court. The same penalty shall be imposed upon any person who, having sufficient funds in or credit with the drawee bank when he makes or draws and issues a check, shall fail to keep sufficient funds or to maintain a credit to cover the full amount of the check if presented within a period of 90 days from the date appearing thereon, for which reason it is dishonored by the drawee bank. Where the check is drawn by a corporation, company, or entity, the person or persons who actually signed the check on behalf of such drawer shall be liable under this Act. What is the evidence of knowledge of insufficient funds? Section 2. Evidence of knowledge of insufficient funds. The making, drawing and issuance of a check payment of which is refused by the drawee because of insufficient funds in or credit with such bank, when presented within 90 days from the date of the check, shall be prima facie evidence of knowledge of such insufficiency of funds or credit unless such maker or drawer pays the holder thereof the amount due thereon, or makes arrangements for payment in full by the drawee of such check within 5 banking days after receiving notice that such check has not been paid by the drawee. What is the duty of the drawee bank when refusing to pay the check? Section 3. It shall be the duty of the drawee of any check, when refusing to pay the same to the holder thereof upon presentment, to cause to be written, printed, or stamped in plain language thereon, or attached thereto, the reason for drawee's dishonor or refusal to pay the same, provided that where there are no sufficient funds in or credit with such drawee bank, such fact shall always be explicitly stated in the notice of dishonor or refusal. In all prosecutions under this Act, the introduction in evidence of any unpaid and dishonored check, having the drawee's refusal to pay stamped or written thereon or attached thereto, with the reason therefor as aforesaid, shall be prima facie evidence of the making or issuance of said check, and the due presentment to the drawee for payment and the dishonor thereof, and that the same was properly dishonored for the reason written, stamped or attached by the drawee on such dishonored check. Notwithstanding receipt of an order to stop payment, the drawee shall state in the notice that there were no sufficient funds in or credit with such bank for the payment in full of such check, if such be the fact. How does the word credit under this law be construed? Section 4. The word credit as used herein shall be construed to mean an arrangement or understanding with the bank for the payment of such check. Can a person be held liable, both under Batas Pambansa Bilang 22 and under the Revised Penal Code for estafa? Section 5. Prosecution under this Act shall be without prejudice to any liability for violation of any provision of the Revised Penal Code. When did Batas Pambansa Bilang 22 take effect? Section 7. Effectivity. This Act shall take effect 15 days after publication in the Official Gazette. BP Bilang 22 was approved April 3, 1979.